champion of the world.
As I mentioned at the end of the previous episode, John's PFA at this point was set to expire on September 15th, 2015. We are roughly mid-August right now, about a year removed from the previous happenings with the Phillipsburg Church of Latter-day Saints, Tara staying with Hope Martin, and all of the marital property being stolen out of the home by Tara, with John having no recourse to get it back. Thanks again for tuning in, by the way. I appreciate you folks sticking with it up to this point. I promise it might not get better, so to speak, but it definitely gets more interesting, at least in terms of the amount of peculiar behavior from many different entities. I want to remind all of you that you can follow along with the official documents. In fact, I recommend it by going to corruptclearfield.com and clicking the link for the Dropbox file where all of the documents are publicly accessible for everyone. Right now, we are going to read a police report. We've already read a police report from earlier. It's time to read another one roughly 1 year later, August 16th, 2015, essentially 30 days out from John's PFA expiring. Once the PFA expires, of course, the gig is up for Tara. She no longer has the sway, she no longer has the authority over John that the PFA affords her. Officer Curry of the Lawrence Township Police Department writes, "The complainant stopped on station," I think that means stopped by the station, "on this date and reported a possible PFA violation that she believes occurred. She stated that she was pulling onto Robinson Avenue to attend church services at the Jubilee Christian Center and saw a red van. Inside the red van was her husband, John Joseph Gill, whom she has an active PFA on. He did not say anything to her, and he only looked in her direction. She indicated that he was wearing a yellow hat at the time. She then pulled into the church parking lot and parked her vehicle. She spoke with Pat Parks and Sharon Bloom, who stated that the male circled the parking lot 2 times, then left. He did not stop the vehicle, get out of the vehicle, nor did he say anything to her. The complainant then reported another incident at her residence on Daisy Street and stated that she believes Mr. Gill was outside of her residence asking a neighbor questions about the garage at the end of the street. She stated that at that time she could not see his face, but heard his voice and recognized it as her husband's voice. She stated that this happened on August 3rd. Remember, this is August 16th, 13 days later. She stated that this happened on August 3rd, and she did not report it to the police as she never saw his face. She feels that John is stalking her based on those 2 events and other events that have occurred in Clearfield Borough in the past. I tried to explain to her that since there was no contact, a PFA violation probably would not go through in the court system. However, she insisted that he was stalking her. I again tried to explain to her that we would have to prove stalking through multiple contacts. She did not feel like this answer was good enough, and I told her I would consult with the district attorney's office to see if they felt a violation occurred and let her know the ruling. So, we have Tara, who goes to the Lawrence Township Police Station. She tells Officer Curry that John had stalked her at the Jubilee Christian Center by circling the parking lot 2 times and then leaving. Then she tells Officer Curry that John had driven past her house a few days prior, and she didn't report it. Actually, a few days is probably too generous. 13 days prior, supposedly fearful for her life, but did not report it at the time because she didn't see his face, even though she heard his voice, recognized it was his voice, and you would think, presumably, knew that it was his car. That'll all come into play later. I just wanted to make sure that we are all on the same page here as to what just took place with that police report. Also, of great interest is the fact that Officer Curry, though she has explained to Tara, it would seem twice in this police report that there was nothing constituting a PFA violation in any of what Tara explained to her, she was still going to go and contact the district attorney's office of Clearfield to find out if they thought a violation had occurred. Now, I have talked with folks at the Lawrence Township Police Department, namely the police chief, and I've also talked with other members of law enforcement from various other places throughout the country that I happen to know. They explained to me that the district attorney's office does not, I repeat, does not like to get involved in matters like this with local police, because when the police believe that the district attorney's office is policing the police, it tends to lead to some very tense circumstances as far far as working conditions are concerned. So really, these different departments like to segregate their responsibilities, and they do not like to pry into one another's affairs. What is, however, ambiguous about this police statement is whether or not it was Tara's suggestion that Officer Curry check with the Clearfield County District Attorney's Office to see if they thought a violation had occurred, or whether this was Officer Curry's idea to check with the Clearfield County District Attorney's Office to see if a violation had occurred. Now, that's important. It's very important to know who it was that suggested this idea first. And as with many of the things I've told you so far, store that one away in your brain because it's going to be very important, crucially important, a little bit later down the road. Now let's get to the actual allegations themselves. I spoke with John, and he said Tara, from the time she left Hope Martin's house until the time of this violation, so roughly over a 1-year period, had been going from church to church in Clearfield and Hyde and all of the surrounding communities, and essentially destroying John's reputation, talking about how he was an abuser, how he had treated her poorly, how he was not fit to be a minister. Now, for a man who is over 75 years old and has been a minister for over 50 years, you can imagine that this was a blow to his reputation that was extremely concerning to him. Remember, the man does not have so much as a parking ticket in the county of Clearfield throughout the past 50 years. So as any concerned, reasonable citizen would do at this point, John was finding out what churches Tara had gone to, and the week after she went to them, he would show up and attempt to share his side of the story to clear his reputation. Well, in one way or another, Tara had found out about this, and so she spoke at the Jubilee Christian Center 1 week prior. John shows up the next week, and she happens to be there. Now, John left right away. The police report even says as much, and Officer Curry agreed, at least implicitly with John, that no violation had occurred because as soon as he saw Tara was there, he left, knowing that to make contact or to stick around would constitute a PFA violation. He did the right thing. He did what he was supposed to do. Though he was innocent of having a PFA on him in the first place, he still stuck to the letter of the law, so to speak. Now, Officer Curry dismissed these allegations by Tara as being allegations that could not be substantiated. They had no rhyme or reason to them. And by the way, if you didn't already figure it out, that was document number 4 in the Dropbox file. I'm guessing you were already reading along with this police report, but in case you weren't and you want to read it for yourself, pause this podcast. Document number 4 in the Dropbox file. Now we move on to document number 5. This is almost unbelievable if I didn't actually know for a fact that it happened. You see, on August 16th, 2015, Tara made these allegations, Officer Curry dismissed them, and everything seemed to be just fine. John hadn't violated the PFA arrangement, and he was still on course to have his PFA expire on September 15th, 2015. That all changes on August 29th, 2015, 13 days after Tara had contacted Officer Curry trying to lobby additional PFA violations onto John's record. Officer Dan Podliski is called out to Tara's residence on August 29th, 2015. I'll read to you the report. Again, this is document number 5. On 8/29/15, I was dispatched to contact Tara Gill. This affiant made contact with Tara, affiant being the police officer, Officer Podliski. This affiant made contact with Tara, who stated that she is still being harassed and stalked by her husband, John Gill. Tara went on to state that on 8/29/15, the day of, that he's making the report, she was posting items for sale on Facebook. That'll be important in a second. Tara stated that people were responding to the ads and she was getting many notifications. Tara stated that she clicked on those notifications on Facebook and saw that John Gill had liked one of her posts. Tara stated that in her protection from abuse order issued by Judge Cherry, it reads that the defendant is prohibited from having any contact with the plaintiff or any person protected under this order either directly or indirectly through third parties, by email, cell phones, text messages, instant messages, blogs, through social networking sites, including but not limited to Facebook, MySpace, Twitter, or by any other electronic means, including no postings of any kind about the victim. Okay, so, and there's one more sentence, by the way, to read on this police report, but let's just recap here. Tara is claiming that John liked, and for those of you who know what Facebook is, I don't need to explain. For those of you who might not know what Facebook is, essentially when somebody makes a post, you can like it, which is just simply a button you click underneath of the post to let the person who originally made the post and other people who view the post see that you like this, you appreciate it. Tara is claiming on 8/29 that John liked one of her Facebook posts. For some reason, unbeknownst to me or anyone I've asked, the next sentence says, on 8/31, 2 days after 8/29, on 8/31/15, Tara came to the Clearfield Borough Police Department with pictures of the post from her Facebook account. This affiant, that means again the police officer, Officer Podliski, this affiant did see a post by Tara and a comment below that John Gill had liked the post. Images were photographed by this affiant. A few WTF moments here. First of all, why was this evidence not collected on 8/29 when Officer Podliski first contacted Tara? Says he was dispatched to contact Tara Gill. Why did he not collect this evidence on that day, on 8/29? Why is it that 2 days later, 2 days after the fact, Tara waltzes into the Clearfield Borough Police Department, not with a device, laptop, cell phone, tablet, not a device showing that John had liked the Facebook post, but with pictures of a computer screen. Why didn't Officer Podliski take pictures of the computer screen himself then? And furthermore, it says here that Officer Podliski took photographs of the digital screen. Now, I don't have police training. I have no investigative training. But it seems to me that allowing a plaintiff, a complainant, 2 days after the fact to bring in damning evidence in the form of a picture as opposed to actual evidence of the original point of contact, and then not only do you not actually check the point of contact yourself, you take pictures of the picture. It's quite the paradox, quite the conundrum. I'd very much like to know from the Clearfield Borough Police Department if this is standard policy for all of their cases. Now, this may sound ridiculous, and it is, but it gets better. Remember those charges that Officer Curry at the Lawrence Township Police Department had determined were not worthy of pursuit? Well, Officer Podliski had no such reservation. You see, on September 1st, the day after Tara brought the evidence in, on September 1st, a new police criminal complaint was filed. This is document number 6 in the Dropbox folder. And what is most interesting to note about this document is the fact that it is a carbon copy of the charges from August 16th that Officer Curry had deemed not worthy of pursuit. I would read it to you, but it's pretty much the same thing that Tara had told Officer Curry, and that Officer Curry had said there is no basis for charging John with anything. I will read you the second half of Officer Podliski's police report from September 1st, because it is extremely interesting and contains a few nuggets of information that I think are vitally important. And remember to bear in mind at this point, John has already been arrested. As of 8/31, with the pictures of the actual screen, Tara brought into evidence that John had pressed the like button on Facebook on one of her posts, and Officer Podliski took pictures of the screen and then proceeded to arrest John. That speaks directly to the second half I'm going to read here. You see, even though this complaint, where all of those charges from Officer Curry were rehashed and John was charged for those, it also reads tells us exactly what happened on the date that John was arrested, on 8/31. Here you go. On 8/31/15, this Officer Podliski, obtained an arrest warrant for John Gill based on a PFA violation, talking about the Facebook like. Upon taking John into custody at his residence, John asked officers to turn off his computer. On his printer, this affiant, Officer Podliski, observed printouts of Tara Gill's Facebook posts. The printouts were seized by this affiant. Tara was questioned by this officer as to the items that were printed by John and whether there were marital property involved. Tara stated that there was not, and that she has no idea why John would have concern for the items. Tara stated to this officer that she is in fear for her life. Tara stated that she believes John will do something to harm her physically. She informed this officer that she does have a medical condition, which she is directed by the doctor not to be under stress for. Tara stated that John is aware of her condition. Based on the above, this affiant believes that John Gill engages in this course of conduct to cause Tara substantial emotional distress. Now, what I find most interesting about Officer Podliski's statement here is the fact that he collected printouts that were on John's printer showing that he had printed off Tara's Facebook posts. And remember, those posts were not her actual status updates. They were items she was selling online. Items that happened to belong to John. But still did not check to see whether or not on John's computer John had actually liked Tara's Facebook post, and still did not collect any evidence of John liking the Facebook post on Tara's devices until 2 days later, the 31st. Very strange, in my opinion, to collect these printouts on John's printer when they really have no bearing on the evidence of the actual allegation that the complainant, Tara, is making, but also that he would specifically state that he took those and seized them while not actually requiring any evidence to be documented of the allegation that they had came there for on that initial visit. In fact, I don't know the laws and exactly how they work, but without actually collecting evidence and the judge himself not seeing evidence, I'm a bit perplexed as to how the warrant was even issued for John in the first place. My thought would be some sort of judicial standard where the judge would need to see clear and present evidence of a violation that was committed in order for something like this to be issued. But I digress, and again, I do not know the legal system. I do, however, know that Tara told a massive lie at this point. She claimed that there was no reason for John to have concern for the items in the Facebook post that he was printing out. In fact, this goes all the way back to Tara pilfering all his possessions by calling it marital property and having the Phillipsburg Church of Latter-day Saints raid his house while he sat next door at the church. You see, John began to see the items that were stolen from him pop up on Facebook, Tara auctioning them off, selling them to folks on pages like Clearfield Live and Du Bois Live, which are essentially the local equivalents of Craigslist, only on Facebook and for just that Clearfield County area. He had great interest in these items because, as he was told when he contacted the police station and petitioned the courts after Tara had taken the items from the house, the only way he would get those items back is if he documented everything and then took her to civil court for the matter. So it was extremely imperative that John would actually document all of these items, and if he saw them pop up on a social media site, that he make print-offs and document those items as well. Tara, of course, says this is not marital property, and John has no concern for these items. She has no idea why he would be printing off pictures of the items. Now, pressing a like button is a cut and dry thing. I can't prove that you were trying to stalk me if I drive to my church, the Jubilee Christian Center, and you're there, you drive around the parking lot 2 times allegedly, and then you leave. That is up to law enforcement's discretion. That is up to a judge's discretion, whether or not a PFA violation has been committed. But either a Facebook post is liked or a Facebook post is not liked. That's it, folks. Cut and dry, black and white. There is no ambiguity. When I asked John why he would press the like button on Facebook, he said at the earliest time I asked him, and maintains to this day, I don't remember pressing it. They say I did it, so I must have accidentally done it. Let me repeat that again. They say I did it, so I must have accidentally done it. You see, you expect when law enforcement, when the judicial system, when they come after you and they tell you you've done something wrong and they lock you up, because we do have a justice system that provides due process to all citizens, you expect to be dealt with fairly and honestly. So while maybe a little naive, it is certainly understandable that John says, in his words, I don't remember pressing the button, but they say I did it, so I must have accidentally done it. The curious thing, though, curious to this day, is why the copy of the police report that Officer Podliski filed, that I petitioned from the Clearfield County Courthouse, had no pictures attached to it. In fact, what is so surprising about this fact is that the report itself says that there are pictures attached, yet there are no pictures attached to the file. This will certainly be something we revisit later in the case. But before we move on, I want to recap what has just occurred. Because less than 1 month away from having his PFA expire, having his life go back to normal, having to not look over his shoulder every time he leaves his house, John's life has unexpectedly and suddenly descended into a nightmare. The PFA violation, which was pressing the like button, contact is what they call it. John established unlawful contact with Tara by pressing the like button. He has a hearing scheduled on October 27th, 2015, 10/27/15. On the flip side, those charges that Officer Curry originally recommended should not be pursued, they've now been slapped back on him by Officer Podliski 15 days before the expiration of his PFA, and he's now staring at charges for stalking and harassment. The last thing I want to mention here is the difference between these two charges and why they're important. Stalking is a misdemeanor of the first degree in Pennsylvania. If you're accused of stalking, you have the right to a jury trial, a jury of your peers. Harassment is what's known as a summary offense. A summary offense means a judge will hear the evidence from both sides and will unilaterally make the decision as to whether or not the defendant is guilty or innocent. There is no jury afforded. If you look carefully at document number 6 and you view the charges themselves, you'll see harassment, you'll see stalking, and if you read the acts of the accused associated with this offense, which is essentially the description of the offense, you will see that both descriptions of these two separate charges are exactly the same. They are both for the incident at the Jubilee Christian Center where John supposedly drove around twice and then left, and the incident where John drove down the alley behind Tara's house. She did not see his face, but she swears she heard his voice. 2 charges, same exact description. One affords a jury trial, the other is solely at the judge's discretion. Now, in the interest of fairness, this is not uncommon. Oftentimes, prosecutors will slap 2, 3, 4, 5 charges for the same exact thing on a defendant. So that way, if 1 or 2 of the charges don't happen to stick or the criteria is not legally met for those charges, they will still have some charges to fall back on to make sure that a guilty defendant does not slip away accidentally as innocent simply by a technicality. So this isn't entirely unprecedented, but as you're about to find out a few episodes down the road, it may not be unprecedented, but it was certainly planned. Thanks for listening to this episode of Corrupt Clearfield. Remember, you can follow along with all of the documents I'm referencing at corruptclearfield.com. Just scroll down and click the link to the Dropbox file. All the documents are cataloged in order as they appear in each episode. You can also help to support this investigation as it continues, and also our family as we attempt to recover from the damage that has been done. You can donate either by going to corruptclearfield.com and clicking the link as you scroll down the page, or you can go directly to paypal.me/CrazyGaby. That's my broadcasting alias. Again, that's paypal.me/CRAZ as in zebra, YGAB as in Bravo, EY. Thanks for listening. Until next episode.